Hello everyone, welcome you all at my YouTube channel Law with Logic. Before proceeding with my channel, I want to give you a brief intro about my channel that this channel is totally educational. Anyone who is interested to learn something in the field of law can subscribe. Here we start with Indian Evidence Act, which is one of the major act in India. Before proceeding further, I would like to request everyone who is watching my channel for learning something in the field of law that please read the preamble of every act. Indian Evidence Act came into force on September 1st, 1872, divided into three parts and 11 chapters, which comprises of total 167 sections. Part 1 of the Act deals with the relevancy of the facts. Part 2 deals with proof and the various kind of evidence. Part 3 deals with the prediction and effect of evidence. In the case of Kalyan Kumar Gogoi versus Ashutosh Agnihotri and others 2011, the Supreme Court of India made the following observation on evidence. That is, the word evidence has been used in common parlance in their different sense. First, as equivalent to relevant, as equivalent to proof, and as equivalent to the material based on which court conclude the existence or non-existence of disputed facts. Now, before entering in the vast and complex world of Evidence Act, we need to understand some basics of it, which are more important to understand a large picture, and we can say that it can help us to understand the large picture of Evidence Act. Most of the students and the people who are new in this field just not give huge importance to these basic terminology, but I am telling you that if you really want to learn and understand the root of any case, you have to understand these terminology in a very deft manner so that you can able to resolve the puzzle which were and which will occur in any case. Here we start with section 3 of Indian Evidence Act, which is interpretation clause. Section 3 of Indian Evidence Act 1872 contains details on the interpretation of the terms like code, fact, relevant, fact and issue, document, evidence, proved, disproved, not proved, India, unless the context implies a contrary intention in it. Now, we shall now take up each of these words which are defined in section 3 of this act. Court has been defined in section 3 as including all judges and magistrate and all person except arbitrators legally authorized to take evidence. In case of CIT versus East Coast Commercial Corporation Limited 1967, it was held that income tax authority do not fall under the definition of court. Interestingly, to note that 69th Law Commission report recommended making a comprehensive definition of court to avoid confusion. The Law Commission definition includes civil, criminal, revenue code, and tribunals within the definition of court. However, the definition of court has not been amended to include revenue courts or tribunals till date. If you want me to discuss the citation in more detail, do let me know in comment section. Now we take the other word, which is fact. Fact means and includes anything, state of things, or relation of things capable of being perceived by the senses. And the second one is any mental condition of which any person is conscious. Here we take some illustration regarding the same. We can say that if there are certain objects arranged in a certain order in a certain place is a fact. In simple language, we can say that a man can hear or say something as a fact. We can say that if a man carry any kind of reputation as a fact. So we can say that a man holds a certain opinion, has a certain intention, act in a good faith or fraudulently, or uses a particular word in a particular sense, or is on was at a specific time conscious of a particular sensation as a fact. Here we took the another word which is relevant. Relevant is defined as one fact which is said to be relevant to another when the one is connected with the other in any of the way referred to in the provisions of this act relating to the relevancy of the fact, which means relevant facts are those which are needed to prove or disprove a fact in issue. Relevant facts are also called evidentiary facts, that is, factum probans in legal terminology. These facts are not an issue, they are not the main issue of controversy or dispute between the parties. Now we took the word fact in issue. The expression fact in issue means and include any fact from which, either by itself or in connection with other facts, the existence, non existence, nature, or extent of any right, liability, or disability asserted or denied in any suit or proceeding necessarily follows, which means fact and issue are those facts that are sought to be proved and are called principal fact. And in legal terminology, we can say factum probandum, when the rights and liabilities of the party are dependent on a fact that is in dispute or controversy. That fact is an issue. For example, we can say that whenever, under the provision of law for the time being in force to civil procedure, any court records an issue of fact, the fact to be asserted or denied and the answer to such issue is a fact in issue. Here we took the illustration that A is accused of the murder of B. At his trial, the following facts may be an issue: that A caused B's that. Second one, A intended to cause B's that. Third one, A had received grave and sudden provocation from B, or A at the time of doing the act which caused B's that was by reason of unsoundness of a mind incapable of knowing its nature. Now we take the word document, means any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of those means intend to be used or which may be used for the purpose of recording that matter. Some of the examples of documents are: writing is a document, words printed, lithographed or photographed are documents, a map or plan is document, a caricature is a document. So these are the. In case of R.V. Dave 1908, the court observed that the notches made by banks, bakers, or milkmen on wood to indicate the amount of bread or milk supplied are documents. The surface upon which the writing or marks are inscribed is not restricted to papers. Writing, words and photographs, maps, plan, inscriptions or metallic surfaces, all these fall within the category of documents. In general, what we can say that anything which can gives us any kind of hint, any kind of reading, anything which mind can be intellectually connect is something called document. Now we take the word evidence. Evidence means and includes all statement which the court permits or required to be made before it by witnesses in relation to matter of fact under inquiry. Such statements are called oral evidence. The second one is all documents including electronic records produced for the inspection of the court. Such documents are called documentary evidences. Evidences are of many kinds. If we go in a elaborative manner, we can discuss all the things in a deeper manner. That what is oral evidence, what are hearsay evidence, what are documentary evidence, what are primary evidence, what are secondary evidence, classification of evidence, what are direct and circumstances evidence. So these all the things we will discuss later, that what kind of real and personal evidence are, original and unoriginal evidence are, substantive, non-substantive evidence, positive, negative, prosecution evidence, defense evidence. So more and vast kind of evidence we can discuss further. Now we took the word proved. A fact is to be proved when, after considering the matters before it, the court either believe it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. Opposite to that, the word disproved, which means a fact is said to be disproved when, after considering the matter before it, the court either believes that it does not exist or considers its non existence so probable that a prudent man ought, under the circumstances of the case, to act upon the supposition that it does not exist. And related to these two words, the third one is not proved, which means a fact which is said not to be proved when it is neither proved or disproved. We will discuss all these words and terminology in a deeper manner, that how they all are interchangeably used and related to each other and frequently misrepresent and misguided by the lawyers as and when their case needed it. So, arranging these words and terminology in a fruitful manner as desired by the lawyer depend upon their cases, how they really use these terminology to make out the result which are favorable in their cases. So these are the words which are very much frequently used in the courts, and using these words interchangeably is the art of lawyers, that how they can use it. Now we took section 4 of the act, which define the word may presume. All the words like may presume, shall presume, and conclusive proof, and the words we gone through with earlier, that is proved, disproved, what is evidence, and all these are the normal terminology, but they are the basic building block of every case, because all the cases depend upon these terminology in a directly manner. sometimes it depends that how you can prove these terminology and how you can fructify these terminology in your favor, so that you can able to decide your case in your favor. So these are the arts which lawyers have. And from the point of view of any student, I must say that if you clear these words and if you are very much sure about these words, that where it applicable, where we can use it, then you can do anything. So the word may presume define as whenever it is proved by this court that the court may presume a fact, it may either regard such fact as proved unless and until it is disproved, or may call for proof of it. The word shall presume defines as whenever it is directed by this act that the court shall presume a fact, it shall regard such fact as proved unless and until it is disproved. And the word conclusive proof defined as when one fact is declared by this act to be conclusive proof of another, the court shall, on proof of the one fact, regard the other as proved and shall not allow evidence to be given for the purpose of disproving it. So, this is all for today. We will discuss all these terminology with major citation in our next session. Till then, please like the video and subscribe my channel. Thank you all.